Questions. Before we get into our outline, how many of you have ever participated in a litigation situation, whether personal or professional? Any of you guys have? Yeah, we got a lot. Okay, a lot of you have. Well, is that something that you thought, hey, that was cool, let's do that again this year? It's like, probably not. I mean, that was probably the most stressful thing that you've ever been through in your life so far. And it seemed like it was just like never going to stop. It just goes on and on and on. And when you see your name written on legal documents, whether it's challenging your personal integrity or whether it's challenging the care that you've rendered, that's pretty intimidating. And a lot of times the legal words that are surrounding that, you don't really understand exactly what is it that means. It sounds bad, but what does that mean for me? Well, medical malpractice is kind of the same way. And so for those of you that haven't had that wonderful experience to go through, I'm going to share with you, and we're going to lay the groundwork for the rest of the day to help you understand how does medical negligence get started in litigation. Because in healthcare, it is very prevalent. And so I want you to have a broad picture of what it is that we're dealing with and how it gets started so we can relate back to why is it so important that we focus on documentation and why nurses get involved in litigation. Okay? So, in the very beginning, before medical malpractice can even be filed, an injury has to occur to somebody. So you have an individual who's gone to a healthcare facility or a provider, and they have sustained an injury of some kind by that individual. Okay? Because of that injury, they feel like, hey, that shouldn't have happened to me. I deserve monetary compensation for that. And so they seek out a plaintiff's attorney in order to obtain that. A plaintiff's attorney is the one that's going to be able to file what they call a medical malpractice cause of action lawsuit against the facility or the provider. Okay? So once they bring their story to the plaintiff's attorney, he's going to be listening to that story to try and determine, do we have a case or not? He's going to have a member of the healthcare team working with him and listening to that story as well. Usually it's a nurse, it can be a doctor, but someone that's got, the ear and the eye for medicine, nursing. Because he's experienced in law, but we know medicine and nursing. And we also know that sometimes the care that our patients think that they received is not necessarily what they got. So the story, is going to be a little filtered when we listen to that. But when we hear the story that the injured party has brought to us in a plaintiff's office, then we're listening for 4 elements that plaintiff's attorney is going to have to prove in order to file a medical malpractice cause of action lawsuit. Now I'm going to tell you very briefly what those 4 things are. They're duty, breach of duty, damages, and causation. Okay? So duty is simply this. We all have a duty to provide good quality of care to all the patients that we take care of. And they have a right to receive that care. Okay? It's just our duty. We have a duty to do that. Then you have breach of duty. Breach of duty is simply this. Either we did something that we shouldn't have done, or we didn't do something that we should have done. That's essentially breach of duty. Okay? Duty, breach of duty, damages. The damages can be physical damages, like loss of a limb or an anoxic problem. It can be emotional damages. It can be financial damages, an extended length of hospitalization of 2, 3, 4 months. Okay? So the damages can vary a little bit. We're pretty much focusing on the physical damages today, okay, of the injuries that have occurred. So you have duty, breach of duty, damages. Then you have causation. Causation is the 4th prong, and it is the most difficult component that the plaintiff's attorney has to prove in order to file a medical malpractice cause of action lawsuit. What causation is this. The plaintiff's attorney has to be able to prove that what the nurses did or did not do caused the injuries. Now let me give you an example of what that means. If I told you that a nurse administered 80 milliequivalents of potassium, IV push, to this guy, okay? And a couple minutes later, he went into a life-threatening dysrhythmia and died. Would you say, yeah, no duh? What would you expect, right? We know that 80 milliequivalents of potassium is going to cause some harm, if not death, to somebody. Because we don't do that. We have to drip it in, even at 10 milliequivalents. You just don't do it. That's causation, because the plaintiff can then prove that 80 milliequivalents of potassium is going to cause some cardiac problems. Okay? That's causation. Once we feel that there has been, you know what, I think we have a case. I hear those things going through. The plaintiff's attorney says, I think we can do this. Then he's going to say, I want to take a closer look. What he means by that is he wants to get a copy of the medical records. So he's going to send some legal documents across to the defense counsel who's representing the individual over the facility and request a copy of those medical records to be sent over. A copy of those medical records are going to be brought to the plaintiff's office. He's going to make a copy of those, give them to a nurse who's going to be working with him. She's going to begin to review that medical record and compare it to the story what they heard in the office and see if it matches. Okay? Because sometimes it's different. Now that's what the plaintiff is going to do to get started. Now let's see what the defense is going to do. Okay? The defense probably already knows that they're going to have a problem with this case. Why? When bad things happen in a hospital, what do we do about it? We talk about it, right? It's like, oh man, you should have been here yesterday. I can't believe it. Oh, it was bad in that room. Oh, you've never seen so much stuff. I mean, it goes all the way up the food chain. Immediately, it's boom, you know, the CNO gets it, the CEO gets it, the risk manager gets it, your public relations people try and keep it out of the media. I mean, it's a big deal when something bad happens in a hospital. Well, your defense counsel probably already knows. And when the letter comes across, it says, we're going to file a lawsuit. It said, yep, it's just a matter of time. Okay? So he has a nurse working with him. They're going to look at the medical record, check out the allegations. They're going to be sent across and say, okay, what are we going to do with this? They're going to check the allegations, and the nurse is going to render one of two recommendations to that defense counsel. She's going to say, you know what? Let them sue. We did everything that we were supposed to do right. We can defend this case. Absolutely, we can defend this case. We followed the 5 rights of medication administration. We followed our own hospital policies and procedures. We communicated timely with the physician when we recognized postoperative complications. Let them sue. We can defend this case. Or she may make a recommendation and say, you know what, we did a lot of things really, really good. However, there's a gap between midnight and 6 o'clock in the morning. The patient wasn't doing very well, and we didn't call the doctor. That's going to be a problem for us. Okay? So the defense counsel is going to make a determination. Okay, what are we going to do about this? Most defense counsels say we're going to deny everything and we're going to defend it all the way. And so they're going to take it and so just put the posture on and we're going to trial. In order to do that, they have to have an expert witness in nursing to represent the standard of care that the nurses did adhere to. So they're going to go around the country to find a nurse just like you or me with similar like background, with a similar like training and knowledge that has worked in the area that the nurse that's in trouble has done. And she's going to testify to the fact that the nurses adhered to the standards of care. Meaning that they followed the 5 rights of medication administration. They followed their own hospital policies and procedures. They communicated timely with the physician when they recognized postoperative signs and symptoms of complications. Okay? In fact, I think they exceeded the standards of care on so many other things. And then she makes the list. So they have set their team in motion of how they're going to defend this case. The plaintiff on this side is going to do exactly the same thing. They're going to go around the country and find a nurse, similar like background, similar like training, that's worked in the area that the nurse that's in trouble has done. Only their testimony is going to be the nurses breached the standard of care, meaning they failed to follow the 5 rights of medication administration. They failed to follow their own hospital policies and procedures. They failed to communicate timely with the physician because you know why? They didn't even recognize signs and symptoms of postoperative complications. They breached so many standards of care, I can't even count them all. You see, the position is totally different. Then they're going to take their positions and they are actually going to go to trial. Okay? They're going to go to trial, they're going to have a judge, and they're going to have a jury, and they're going to hear all the testimony, the nurses that took care of the patient, the expert witnesses on both sides, and the jury is going to make a decision on who they think is, you know, most believable. Okay? So if they side with one or the other, that's where the verdict is going to be. Well, let me ask you this. When these expert witnesses read that medical record, they have to formulate an opinion on what they think the nurses did or did not do based upon reading that medical record. So when they get in there and they read that medical record, they're making, you know, an assumption or they're drawing some conclusions. Do you want a third-party person who doesn't know you at all, who's never been in your hospital, who's never set foot in a place where you do care on your patients, make a determination of what you did or did not do that's going to affect you the rest of your life? I don't think so. You know, I think it'd be more important that, you know, hey, our record needs to stand alone. It needs to be firm. It needs to be precise. It needs to be accurate so that even if you are brought into litigation, hey, you can read your record even when you're nervous. You just read it, and that's what it is that you did, because it has happened a long time ago. Instead of trying to say, I don't know what I did, I don't remember, and then it's very difficult, very difficult. So we're going to work on that today, and we're going to try and shore up your documentation wherever it is that you are so that we can hopefully avoid you participating in that real uncomfortable situation.